Denied. That is the latest ruling in the civil lawsuit against the head of the South Carolina Law Enforcement Division from a low-country hemp farmer. A judge ordered SLED Chief Mark Keel to pay the farmer's attorney $11,000 for multiple discovery abuses.
And the SLED chief asked the judge to reconsider the sanctions against him. Well, the judge said no. Chief Investigator Jody Barr caught up with the man who appointed Keel to ask about the judge's findings.
We asked South Carolina Governor Henry McMaster to sit down with us to answer questions about the February discovery abuse sanctions handed down against his appointee, SLED Chief Mark Keel.
It looked like they were coming to take down an army of criminals or something. I didn't know that it took that many people or that much equipment and much manpower to come to one farmer standing in a hemp field.
Trent Pendarvis, a Dorchester County hemp farmer, sued SLED and Mark Keel, along with multiple other agencies involved in the destruction of his hemp crop in 2019. The lawsuit is still pending. SLED charged Pendarvis with unlawfully growing hemp, although the farmer held a valid license to grow it. The problem, the farmer planted the crop in a different field on his farm from the one he originally listed on his hemp farming application.
All right. Good afternoon, everyone.
In a February order, Circuit Court Judge Maite Murphy wrote, Keel's written responses to the farmer's lawsuit are examples of his intentional, willful, and bad faith nature of Keel's discovery conduct. Failing to properly respond, ignoring written notifications of deficient responses, forcing the plaintiff to file motions, forcing the court to schedule hearings, and then at the last minute, attempting to cure the deficiency is not conducting discovery in good faith and is evidence of intentional, willful, and bad faith conduct. I find that the prejudice to the plaintiff from Keel's conduct is clear, convincing, and substantial. Basic discovery in this case has now been delayed for over a year. Hey, Governor.
How you doing?
I'm Jody Barr.
I bet you are.
The governor would not agree to schedule a sit-down interview with us to talk about the sanctions against the state's top law enforcer,
Governor, Lieutenant Governor,
who is also a member of the governor's cabinet. Instead,
Thank you.
McMaster's staff asked us to ask our questions at one of the governor's public appearances, where time for questions is often cut short. Were you able to read the order from Judge Murphy regarding Chief Keel's?
I haven't had a chance to read it. I've just read newspaper reports.
And when you read that as an attorney yourself, as a former attorney general of this state, now governor, what do you think when you read that about a cabinet appointee?
Well, that's what the judicial system's for. As Paul Harvey says, no, that's the rest of the story, you know. I think that's what the judicial system's for. And it sounds like the matter is going through, it's a civil matter, and it's going through the judicial system.
And in the judge's order, she writes, I find that Keel's conduct regarding discovery in this case has been dilatory, prejudicial, willful, intentional, and in bad faith, and that his responses have been false, misleading, and incomplete.
Yeah. Well, I read some of those words, but again, that's the judge's order, and she's doing her job. Chief Keel has been in law enforcement a long time. He has a terrific reputation. His whole organization does. But again, this is a civil lawsuit, and it's going through the proper steps.
During our investigation into the hemp farmer's lawsuit, law enforcement sources sent us this: SLED's truthfulness policy, a policy ordering that agents shall be truthful and use complete candor in all official matters, whether in the course of employment or otherwise, unless deception is part of a necessary and approved investigative pretense or undercover operation. The policy goes on to order employees shall be truthful and complete in all written and oral reports and statements pertaining to division business and related activities. The truthfulness policy went into effect in 1992, a policy that applies to every SLED employee, a policy enacted and ordered by SLED Chief Mark Keel. The last question I have for you is, SLED has a truthfulness policy. And truthfulness policy, and it was signed by Chief Keel. 2021 when it was updated, and it says in that policy, employees shall be truthful and use complete candor in all official matters, whether in the course of employment or otherwise.
I understand, and of course there are always two sides to every story, and that's what the judicial system is for. Chief Keel has been a respected law enforcement officer for many, many years. I've worked with him for many, many years. I have confidence, high confidence in him. Of course, the judge has a good reputation, but that's what the legal system is for, is to sort these things out in a methodical procedure that is set by law, and that's what's happening.
Who should hold Chief Keel accountable for what this judge has
You
found?
ask that same question.
Well, who holds him accountable? I mean,
Well, that's what the judicial system is for.
Chief Keel and his attorney asked the judge to reconsider the sanctions ordered against him, including removing Keel's name from the order. Clearly, the plaintiff has not sued Director Keel individually, yet throughout the court's February 28, 2023 order, the court refers to the defendant only as Keel, which is incorrectly suggestive that Mark Keel individually has been sued and that the court's order and findings personally are directed against Mark Keel individually. To accurately reflect who the proper party is and against whom the order is directed, the court is respectfully requested to alter the order to reflect the proper party as the defendant SLED and to make it clear that this order is not directed at Mark Keel individually. Mark Keel individually was not personally or directly involved in the discovery process, and as a result, the order creates the misconception, or at the very least is misleading, to suggest that the order, its findings, and the sanctions are directed against Mark Keel individually or personally. The farmer's attorney, Patrick McLaughlin, wrote in a court filing in response, arguing there's nothing the judge needs to change. Over the course of 6 filings and 10 separate discovery responses in this case, Keel has self-identified as Defendant Keel in some form or fashion approximately 100 times. SLED Chief Mark Keel still has at least one more option to challenge the judge's order. He could appeal to the state appeals court. I asked Keel and his attorney if they plan to do that. Keel spokesman told me SLED disagrees with this order and is evaluating all available options to challenge it. We'll continue to stay on top of the developments in this lawsuit.